Morning.
Morning, Your Honor. Your Honors. Jeff Bluestein for the Appellant St. Croix Lane Trust. I'd like to reserve 5 minutes for rebuttal if time permits. I don't know whether I'll go over or not. I certainly hope I don't. In any event, getting into the meat of this, it's important, I think, for the court to understand precisely what the facts are that got us here. The facts are different than a lot of the opinions that have been out there addressing the 718-116 joint and several liability. In this particular case, the association foreclosed on its own lien for assessments, didn't show up to bid at the sale. My client purchased the property, and then the association turned around in what we perceived as sort of a gotcha tactic and said, okay, now you're liable for all of this stuff that was due, which was at the time about $36,000, $18,000 of which was assessments, and $18,000 of which was interest, late fees, and attorney fees, never mind the fact that the interest was even compounded. In any event, my client obviously at that point had a dilemma because I think we know what the law is regarding merger otherwise. And so that's how this pursued. My client tried to effect an accord and satisfaction. We always disputed whether this other stuff was included in assessments, and here we are. There are three issues before the court today. One is accord and satisfaction. One is the doctrine of merger. And the third is whether the definition of assessments under 718-116-1A includes interest, late fees, attorney fees, and costs. Just dispensing with this immediately, the issue of merger has become a very weak one. And so I'm not going to spend a lot of time talking on that. At the time suit was filed, at the time the offer was made, we didn't have the Avventura v. Spiaggia case out of the 3rd District, which actually sort of says, hey, you know, merger is kind of counterintuitive with this joint and several liability concept of 718-116 sub 1A. Excuse me for a second. So in any event, Spiaggia has sort of addressed that. I don't know that I necessarily agree with Spiaggia. Interestingly, in Spiaggia, it was the association that was arguing for merger, and it was the third part, the purchaser of the property, which I believe was a third-party purchaser, was arguing against it. But in any event, all I'll address to the court on this issue is that it's unclear. There is a statute. Well, it's that section under 718-116A. I'm sorry, 718-116. It's sub 6 sub A that talks about when the association forecloses on its lien, and it says that it does it in the same manner that a mortgage foreclosure, a bank forecloses on a mortgage. So I would suggest that lends some ambiguity to this. It's unclear whether the Spiaggia court addressed that issue and looked at that ambiguity within the statute to determine whether a merger really exists. But in any event, far weaker issue than accord and satisfaction. Accord and satisfaction is I guess what we started with and what I'll start with here. I think the court well knows, I mean, we're taught this in law school, I mean, it goes way, way back, what an accord and satisfaction is, but it's not always apparent exactly parsing it out what it means. The accord is the offer, the satisfaction of the satisfaction is the performance of the condition accepting the offer. In most instances, we see it in the context of an offer made in connection with a check. A check is tendered subject to the condition. An offer is made that is subject to the condition of acceptance of payment. That is what an accord and satisfaction is. There's been some confusion. There was some confusion in the trial court as to the intent that goes along with that, because there's some law that says you have...
There's not really any dispute here that the claim was disputed. You sent the letter, said we're offering this in full satisfaction. They wrote back and said, no, you understand our position. We're taking the money anyway, and they deposited it. They never tried to return it. And really, we're talking about the last sentence in 718-1163. Isn't that what this case is about?
That's correct, Your Honor. And I don't know what I can. I appreciate you for bringing that to my attention, because I'll skip a whole discussion about that. I completely agree. There's no issue as to whether there is an accord and satisfaction. although the judge thought there might be. The issue really is whether there's some sort of a conflict between accord and satisfaction, which has been codified in 673.3111 and 718.116. It's our position that the plain meaning of that particular statute, or that particular section of the statute, is very clear. It sets forth an order of applying payments that the association is supposed to undertake, first to interest, then to late fees, then to costs and attorney fees, and then to delinquent assessments. The second sentence is, I'm not, Forrest Gump, I am not a smart man, but it seems to me that the second sentence says, okay, well, notwithstanding any restrictive endorsement or anything like that, I mean, maybe it could have used a better term, this is the order that you apply the payment that's received. We didn't contest that. We didn't dispute that. In fact, the association applied the payment precisely first to interest. Now, there wasn't enough left to apply it to whatever else might have been remaining, but they applied it consistent with the statute. And we didn't tell them to do otherwise. That seems perfectly obvious to me. And in fact, I provided the lower court, I provided this court with the legislative history and the staff analysis that is completely consistent with that understanding of the statute. And it talks about, the very last sentence of that legislative history is notwithstanding any other formula for payment that's provided. The statute doesn't say accord and satisfaction, which is different than a restrictive endorsement. It's clear with the legislative history, what's being addressed is, well, we want you just to apply this to interest. Nobody would ever say that. We want you to apply this to delinquent assessment. We don't want to pay your attorney fees or your interest. That's what it's for. I would direct the court's attention also, one of the things that the trial judge got into was, the more specific statute that the 718.116 is more specific than accord and satisfaction, or as codified in 673.3111. And the fact is, by reference to this court's decision in the Cricket case, which was authored by Judge Silverman, that the court made clear that that was a case where you had the extinguishment of the association's claim by virtue of a tax deed. And while the comparison may not be altogether clear, one of the things that Judge Silverman said was that joint and several liability applies only to transfer of title and joint and several liability. The tax deed statute applies to what happens after what happens to title, the claim of lien, once the tax deed is issued. And here we have the same sort of issue as well, as I see it. Settlement by accord and satisfaction is a very different thing than the joint and several liability of 718.116. Not only are they two entirely different things, but the accord and satisfaction is a more specific statute as it relates to settlement of your claim.
I don't understand. If you've got the legislative staff analysis that tells you this is what this is designed to do, this is what it means, why would you get into the weeds of trying to decide which statute was more specific or which was more general? I don't get it.
I don't either, and frankly, I didn't understand it. Maybe I didn't argue well enough to the trial court. I have no idea. As I told Mr. Allen, I felt like I had a bad day that day, and maybe it's reflected in the opinion. I don't know either. I don't have an answer to that. Having said that, one of the things that I know that the appellee is going to rely on is the Oceans 2 case. The problem with the Oceans 2 case is that the Oceans 2 case was an unconditional payment. That is an entirely different matter. And in fact, what the Oceans 2 court was completely concerned about, it is replete within its opinion, it was concerned about this sort of understanding, and it described it almost as this prolific and prevalent understanding throughout the district, perhaps throughout the state, that by accepting a partial payment, after the case has been turned over to an attorney, that would compromise, waive, or somehow impair the association's lien. That was what that case was about. And so, as a result, what Oceans 2 did is there was some language in there that they threw in the accord and satisfaction too, but in the interest of encouraging or discouraging this type of behavior and encouraging the acceptance of unconditional partial payments, they said, the association should take these, the association, the management company, they should accept these payments because the statute protects you. But again, it didn't deal with an unconditional payment, and to that extent, it's even perceived to apply to an accord and satisfaction, and there is a reference to it in there. I can't explain it. I would submit to the court it's dicta, and it probably shouldn't be considered again because that's a conditional payment, and by definition, a payment that's tendered as an accord and satisfaction is a conditional payment, not unconditional. The other issue, and this is a very important one, and it's really causing problems. This is causing problems throughout the state. Is what are assessments? One of the big problems we have here, as I mentioned earlier, was that of the $36,000 claim.
Let me stop you there. Yeah. If the court accepts your argument on the accord and satisfaction, then the rest of this becomes immaterial. Correct. Right?
Yes.
Okay.
And in fact, one of the things we've also asked for, and we believe the court has authority to do this because the intent is established, as Your Honor indicated, the issue of intent on accord and satisfaction is whether or not the payee understood the offer to be in accord and satisfaction. And here, there's an acknowledgement. So we would ask the court to actually instruct the lower court to enter summary judgment in favor of the trust on that issue. Now, as it relates incorrectly, the definition of assessments would become moot if the court did that, but I don't know what the court's going to do. The problem with unpaid assessments is the statute clearly, section 718.116.1a provides for joint and several liability as to unpaid assessments. Quotes, period, that's it. I can never get it right. I hope I get it right now, but Judge Silberman used this Latin concept in deciding the Cricket case, and I hope the court uses it here. Expressio unius est exclusio alterius. The expression of one excludes the other. In 1A, with respect to joint and several liability, the legislature has provided for the recovery of assessments only, unpaid assessments. Throughout the statute, throughout that same section, in sub 6, 1B, sub 5B, 5A, 6B, the legislature specifically provides for the recovery of interest, late fees, costs, and attorney fees incident to the collection of assessments. They specifically provide for it. So it seems to me under that theory, under that rule, and under that interpretation, that's all there is. That's all you get. The legislature knows how to say what it means, and it means what it says. And all it said was unpaid assessments, yet elsewhere it allowed for these other things. Having said that, I think one of the things that was argued, or maybe the court bought into, was, well, if we look at the definition of assessments, assessments really necessarily includes all these things: expenses, interest, late fees, attorney fees, and costs. It doesn't. As my brief indicates, and I think the law is quite clear, it doesn't. Assessments is defined in 718.103, and it's by reference to a share of funds required for payment of the common expenses, a share of funds. Well, if we look to, and there's then we go to common expenses, which is another defined term under 103, and common expenses then refers you out to 718.115. It is a bit of a journey, which tells you what common expenses it include. Now the legislature gets into it, and it says, and this was confirmed in the El Badarami case, and it was confirmed in the U.S. Forest Hills Gardens case that I cited to the court in a subsequent notice. It says that assessments are only permissible if they're pro rata shared among all of the unit owners in accordance with the ownership and the common elements. That's what it says. And the problem that the court in El Badarami had with this is the same problem we have. In El Badarami, an association through its bylaws tried to turn a fine into assessment. And the court went through this analysis of what an assessment is or what it can include, and it said even though your bylaws provide that this is an assessment, that violates Florida law. It's a violation of Florida law because under 103 and 115, assessments cannot be individualized. They cannot only be borne by one party. They have to be shared. They have to be shared by all the unit owners in proportion of their ownership. So, in El Badarami, confirms that. U.S. v. Forest Hill Gardens, which actually deals with unpaid, the term unpaid assessments, but as it relates to a bank, because a bank lives by a slightly different set of rules. But the statute, the statute refers to it the same, unpaid assessments. In U.S. v. Forest Hills, which I think is a Southern District case, the court made the same analysis and said, hey, they're not included. Interest, late fees, attorney fees, and costs are not included in unpaid assessments. Hopefully I am within my 15 minutes, and I would ask for 5.
Right at 5. Thank you.
Thank you.
Good morning, Your Honors. May it please the Court. Todd Allen on behalf of the Appellate St. Croix Condominium Association. As opposing counsel rightly stated, there are really 3 issues that we're trying to address here. The first issue is whether or not the letter and subsequent payment effectuated in court of satisfaction, whether or not the merger doctrine actually applies, and the definition of assessments, whether that necessarily includes attorney's fees, late fees, interest, and costs. To address these in order, Your Honor, as I cited in my brief, the case law in Florida across all districts requires for an accord of satisfaction for there to be mutual intent in the parties to effect a settlement. That clearly is not the case in this situation. My communication with opposing counsel was very clear that we were both relying on 718.116, the restrictive covenant statute, and that we were also relying on the direction given in the Ocean 2 case to not effectuate an accord of satisfaction. The fact that there was no intent to mutually decide this and mutually settle this precludes the appellant from recovering under a...
If that wasn't the intent, wouldn't it have been incumbent upon you to return their check?
Ordinarily, in other circumstances, that would be the case, Your Honor, but under the direction given in Ocean 2, it says that the court specifically said that management companies, association, and association attorneys rejects tendered payment at its apparel. And the court concluded in the end, it said that the non-lawyer in this individual case precisely did what no lawyer is supposed to do, reject payment to reduce the amount of controversy in a collection action, despite the clear protection.
I think the court was at some pains to make clear that they were talking about payment of an undisputed amount, whereas in this case, it was definitely disputed.
I understand what you're saying, Your Honor, but the court was very clear in saying that under no circumstances are you ever to reject a payment because you have the protection of 718.116 sub 3. If there was ever a question of accord of satisfaction or waiver, the court specifically said you have the ability to rely on that protection, and that's what we relied on here, is that we cannot reject a payment according to the direction in that case, and we have the protection of 718.116 sub 3, which allows us to process a payment despite any restrictive endorsement. So we never get to the intent required because the statute allows us to process a payment despite that restrictive endorsement, and we also are able to rely on the direction given in Ocean 2 to prevent items such as this happen. Because if we didn't have this restrictive covenant statute, 718.116 sub 3, and the case law in Oceans 2, associations would be getting checks left and right, trying to settle disputed amounts in lien foreclosure actions, and the association would be stuck sending checks back under the accord and satisfaction theory. The purpose in here is to, and the direction that the court gave in Oceans 2 is to reduce the amount that's in dispute. And so if a payment is applied, even if it is in dispute, we are supposed to apply it according to the statute despite any restrictive endorsement.
What do you make of the staff analysis in the legislative history, which seems to, contain a much more restrictive understanding of what that language was all about?
Well, Your Honor, I don't make much of it. The fact that it says that it's providing for a formula in which payments are to be made, well, this is a dilemma that the association is faced with. Do we accept this as a payment, or do we accept this as a settlement offer? Because now we're having to decide what the actual intent of the payor is and determine, well, do we apply it under the statute, or are we required to return it under the accord satisfaction statute? So the association is really in a difficult position here, Your Honor.
Well, it seems like, you know, if you look at the legislative history, it seems like the legislature was just trying to talk about how the payments would be applied among assessments, interest, costs, attorney's fees, et cetera, and not going into a situation where they were trying to alter the law of accord and satisfaction as it relates to these types of payments.
Well, yes, Your Honor, I understand what you're saying. I don't think that it was the legislative intent to manipulate accord and satisfaction. I think it intended to preserve that, but I think in this particular case, it decided that it needed to give the association the ability to accept payments and not get involved. I mean, the case law specifically, in the state specifically says...
There's one case in the third DCA, and I understand that, and I understand y'all hang your hat on that, but the language in the legislative history seems to say something a little more restrictive and a little different.
Well, I can appreciate that, Your Honor. The legislative history would have you believe that this is how the payment is to be made, and that the payment, despite any restrictive endorsement, if it says to go to assessments only, or to interest only, or to whatever, and not pay the interest or attorney's fees, or however the payer decides they want to make the payment, I still think you get to the intent of the statute is to prevent somebody from manipulating what is actually owed and the amounts that the association is claimed owed, and prevent anybody from trying to manipulate through an accord satisfaction or any other restrictive endorsement what is actually owed.
Is there a distinction between the type of restrictive endorsement that was in Ocean 2 versus one that limits acceptance to satisfaction?
I don't think there's any specific restrictive endorsement that's addressed in either one. I think the decision...
Well, Ocean 2, the specific endorsement was it was to be paid. It was to be accepted and paid to assessments as opposed to other things.
Right. Ocean 2 says you cannot reject a payment. You have to apply it.
And the issue there was whether if you accept the check that says it's supposed to go to assessments, can you still proceed to get your attorney's fees and all the other things? That seems to me to be entirely different than saying, if you cash this check, you are acknowledging we've paid in full.
Well,
that's a whole different distinction.
I disagree, Your Honor. I don't think it is a separate distinction. I think the intent of the legislator...
Well, the intent in Ocean 2 was we want you to go ahead and to put it, it's just a matter of where you put it.
Right.
There was no intention there. The intention here was either accept our check and payment in full or send it back. Either you accepted the payment in full or don't accept it at all.
Well, I understand that, Your Honor, but if we accepted the payment as proffered by the appellant, then we're in conflict with the direction that we can't, the direction that the court gave us in Ocean 2, that we can't reject a payment.
Well, but in Ocean 2, the intent was, of the submitting party was, I want you to take this money. And I want you to apply it here, and then the question becomes, was that going to mess up our claim for the other things? That's nowhere near the same here, because here they say, if you're willing to take this amount of money in satisfaction of our differences, here it is. But if you're not willing to do that, send it back. And that's not what the intent of the intent of the first one was. We really want you to have this money. We just got you to put it on this account.
I understand that, Your Honor, but you're basically asking the association to make the determination: is this a payment or is this a settlement offer? I mean, if the association believes that there is no dispute here as to the amount owed, that according to 718.116, you are owed all of the assessments.
There's a difference of opinion as to whether they owe it or not.
Right, there is a difference.
And so they said, we'll make an offer. You take this amount, and we're off the hook. We're through. Right. If you don't want to take this amount, send it back, and we'll see you in court.
Right, Your Honor. But the difference of opinion is, if it's an amount settled or if it's an amount offered to settle, we have the protection of that language in Oceans 2 and 718.116 that we can apply it if we believe that amount is owed. I mean,
in Oceans 2, I understand there's all that language in Oceans 2, but the court was at pains to say that the amount that was due was undisputed. And here it was anything but undisputed. They offered $840. You said they owed $31,000. And they said, we'll give you $840 in full and final settlement. If you don't want it, send it back.
I understand that, Your Honor. The case law specifically in the second district, though, allows you to do that, and opposing counsel cited to that case in a subsequent filing, the Burke Company versus Hilton Development Company. In that case, that the appellant filed specifically addressed that courts have struggled over the question over where Section 1207 of the Universal Commercial Code, which allows you to accept a payment over a restrictive covenant when you reserve your right. It specifically...
That's been altered now.
Well, but the Second District Court of Appeals, this court, in the Miller versus Jung case...
what's the year on that case?
It's 1978. It hasn't been...
I submit to you the law's been altered since then.
Okay, well, there hasn't been any negative cite towards this, Your Honor, that the Miller-Jung case has actually been receded from. It's our position. I'm sorry, was there a question? Okay.
Well, what do you make of the Martinez case? That's a little more recent.
I'm sorry, Your Honor, I haven't reviewed the Martinez case.
Well, it sure was cited in opposing counsel's brief. Martinez versus South Bay Shore Tower, 979 Southern 2nd, 3rd DCA 2008. On accord and satisfaction?
Well, Your Honor, I think the overall scheme of the court and satisfaction requires that there be mutual intent. I think that the districts across the state require there to be mutual intent to effectuate the settlement. That was never the case here. In fact, the communication was that, listen, we've been with opposing counsels, listen, we've been down this road before. We believe in 718-116 of 30.
The cases say that even if you scratch out a restrictive endorsement on the check, it doesn't matter. If you deposit it, you're bound. That's it. You're done.
Well, but I don't think that's the case, Your Honor. If the Jung case allows you to accept it and reserve your right to continue collecting that, I think that you have the ability, despite a restrictive endorsement, to reserve your right to collect the remaining amounts that are owed.
I don't think that's the law anymore.
Okay. To address the merger versus estoppel doctrine, I think opposing counsel acknowledged that this is a weaker argument. The case law that I cited in my brief specifically stated that the merger doctrine is not applicable in equitable actions. The statute, in accordance with, in 718-116 says that lien foreclosure actions are done in the nature of a mortgage foreclosure action. When you get to Florida Statute 70201, it specifically contemplates condo lien foreclosures as under that equitable nature. So if the case law says that merger and estoppel doesn't apply in equitable situations, then a lien foreclosure is an equitable situation. It's specifically contemplated in the statute, so that doctrine would not apply. And to conclude, Your Honor, to get in the definition of the assessments, the common assessments is defined in the statute as a common expenses, but when you get to the definition of what a common expense is, it's all charges incurred by the association in the performance of its duties. Associations are required to specifically budget for attorney's fees and specifically required to budget for bad debt. These are common expenses that are shared across the community. Now, granted, there are specific instances where an association is required to specifically levy attorney's fees, interest, and late fees on a property, and I think that the definition of common expenses under the umbrella of what assessments is defined to be is sufficient to find that attorney's fees, late fees, costs, and interest are all included in the definition of assessments. If there's no other questions, I'll conclude. Thank you.
Thank you.
There was a lot of discussion about the Oceans case, and I want to be clear on one thing that the Oceans case is, because it's possible that what has been provided to the court by its staff attorneys may not be complete or accurate. I dare not disparage the staff attorneys. I know they do almost an inhuman job, But bear in mind, under Oceans, there were no restrictions. The payment in Oceans was tendered without any restrictions, limitations, or anything like that. It was just a payment. And so the problem in Oceans that the court addressed was simply the fact that the management company had rejected it, quote unquote, because the claim had been turned over to the attorneys. And the court recognized this to be a persistent problem throughout the district or throughout Florida. And the whole purpose of Oceans was to discourage the rejection of partial payments. There was no condition. There was no restriction. Oceans was simply a payment that was made, nothing written on the check, nothing accompanying it by cover letter or by way of condition, restriction, or anything else that you would want to call it. And the association and its management company rejected it and said, our attorneys have this. We can't take any payments from you. And the court in Oceans said, you need to take partial payments. Restrictive endorsements, accord and satisfaction weren't addressed in that case. It was pure.
It seems like what the opinion in Oceans is really getting to was trying to minimize the incurring of attorney's fees and legal costs when there really wasn't any dispute, because they pointed out that if they'd filed suit on this case, they would have been spending a $200 or $300 filing fee to collect a $25 shortfall, and that didn't make any economic sense. So accept the partial payment and don't run up the expenses unnecessarily. That seems to be the underpinning of the decision.
That is the underlying. I mean, that was, in my opinion, that was exactly what the court's concern was. And again, the court was also concerned with this apparent pervasive problem of partial payments, unconditional, unrestricted, being rejected simply because, well, now our attorney's got it. We can't take any payments anymore. So the court is absolutely correct in that regard. I mean, what happened with the third DCA and all the language that Mr. Allen would like to rely on is the court went into the what-ifs. And what-ifs are dicta. And I'm not even sure. I think the court may. I don't want to suggest the court, misspoke. But the words accord and satisfaction do appear in that opinion. But I don't believe that was the third DCA's intent. And to the extent it was, again, it's dicta. As the court indicated, Jung is not the law. It's been superseded. So I think we know that. Interesting concept by Mr. Allen. I'm not really arguing merger, but I'm fascinated that he thinks a merger can't occur in equity. It happens all the time in the case of mortgage foreclosures. I mean, that's what happens, that the mortgage merges into the judgment and loses its existence. That's why we sue, but that's why we have the deficiency statute, is to preserve that right. So you absolutely can have it in equity. Let's see. With respect to the definition of assessments, I think the law is clear. I think my position was articulated sufficiently, and I stand behind that argument. I thank the court for its time today. Does the court have any additional questions for me?
Very good. Thank you. Thank you both.
Thank you, Your Honor.
Thank you, Your Honors.
I can go on. We'll take a break.
Go on.